Can you videotape the doctor's deposition when he's called in for a question and answer session during the course of your lawsuit? Would you like to learn the answer? Come join me as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial attorney practicing law here in the state of New York. The short answer is yes, you can. Now first, let me just go back for a second. A deposition is a question and answer session given under oath. As the injured victim, you will have to give a question and answer session known as a deposition, also known as an examination before trial. It's pretrial testimony. The defense attorneys will have an opportunity to question you about what exactly occurred and what injuries you have because of that. Likewise, in a medical malpractice case, I will have an opportunity to question the doctors that you have sued. And during the course of these depositions, I will now have the opportunity to ask these doctors what they did and why. What were they thinking? What was the standard of care? Now, some injured victims ask, can we videotape the doctor's deposition? The answer is we can, but there are certain procedures that we must follow in order to go ahead and videotape the doctor's deposition. In most instances, in a medical malpractice case, we typically do not videotape the doctor's deposition. There's a significant expense involved in doing so. One of the only times that we will want to do that is if the doctor is elderly or disabled, and there's a very good chance the doctor will be unable to come into court at a later time. In that instance, we can then go ahead, use the videotape at trial to then show portions of it or all of it to the jury. In cases involving medical experts, there are some instances where that medical expert will be unable to come into court and testify. In that instance, we can go ahead and videotape that doctor's testimony. And what will typically be done is that the defense will have an opportunity to question that particular expert in the form of a deposition, asking questions and getting answers from the witness. And then likewise, I will have the ability to ask the doctor what's known as a direct examination, asking the doctor open-ended questions about what he did, why, and what his opinions and conclusions are. And that's critical because that means that if the expert can no longer come into court and testify, maybe he'll be out of town, maybe he'll be busy with his patients, whatever the reason is, now we can use that videotape at trial. And we can only do that if the defense attorneys have had an opportunity to question and cross-examine that particular witness. In that instance, now I have the full opportunity to use the questions and answers on videotape at the time of trial. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what goes on in the litigation process in a medical malpractice case. You know, I recognize that you're probably watching this because you have questions about your own particular matter. Well, as always, if you have legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. I answer questions like yours every single day, and I welcome your call. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's quick video. I'm Gerry Oginski coming to you from New York. Have a wonderful day.